And we are live here. I'm going to bring up the case file, but there is an exciting ruling, and I know you guys are going to want to know about it, so we're going to go ahead and talk about it. I am joined by my reader, Flying Rich, who reads everything for me, because I usually don't wear my glasses and I have to squint and everything else, which, you know, it's just not the way I like to do things. In the comments down below, if you want to check out the description, you can check out the actual filing down there. I'm going to bring it up. Sorry, I accidentally closed it down here, so let me just bring it back up. Give me 1 second here, because I'm a moron and sometimes I just do stuff that's
it's tech, and you know you don't have skills in that area.
Yeah. No, I just all right. So let me go ahead. I will go ahead. There's actually a couple different laws, so I'm going to update the thing because I just got word that we won another case.
What?
All right, so I'm going to go ahead and update. So we're gonna review a couple cases here, okay, guys? So just bear with me, and then yeah, big wins. So
really, it's not even Friday. It's not Document Dump Friday. It's Thursday.
Crazy, right? All right, so the title is going to change a little bit, but so just bear with me. Big.
I want to say hi to Sabar Prince and Shayna Ewing, and I think it's her husband or Jason Ewing, unless it's her brother. There's Jason.
And I'm just going to change the thumbnails here a little bit. All right. Well,
quick edit on the move.
On the fly, man. On the fly. I'll just throw that right there. All right. Let me just do this. Then I'm going to go ahead and change one other thing here, and then we're going to get into it because we have 2 different rulings now, which is freaking awesome. And
very cool.
Both
breaking news while we're breaking news.
Breaking news. So yeah, it's
Sabar Prince is commenting on my phone.
All right, well we don't
Didn't
care,
work.
Rich. So let me just go. Let me just fix this and more. One case is a Firearms Policy Coalition case, and the other one is a GOA case. So let's go ahead. Which one do you want to start with first, Rich?
Let's start with what we're going, the 18-year-olds.
All right. So we got that done. Let me just go back here. Sorry, guys. Just bear with me. Sometimes stuff happens, right?
Hey, Damien Christ, Agorizer, how's it going, guys? Yeah, I'm hiding out from the ATF, so just in case everybody's wondering. Oh, I just realized I'm near Brandon Falls. I could get a selfie.
Yeah. Just go towards Lewis, and you'll be able to get one. All right. So I'm going to bring this up here. 1 second. Damn it. All right. Well, let's look at this one first. And then, well, look at the other one. Damn it! Oh my goodness.
I
Sorry,
don't get
guys.
invited to the party here. What's going on?
You can get invited to the party. Just give me 1 second here.
Yeah, you're good. Hold on, I gotta take this real quick.
All right. So here's the first one. Can you see it, Rich? Rich?
Where am I supposed to see it? Oh, okay. All right, now I see it. So we have Madison M. Laura Sophia Knepley, Logan D. Miller, Second Amendment Foundation, Inc., Firearms Policy Coalition, and this is against the Pennsylvania State Police.
Yeah, and this is up to the Court of Appeals, and if you notice here, some of the amici on here is Josh Prince actually argued it. Some of the amici on here is like Everytown and stuff like that. So whatever. This is the circuit court. This is a 3-judge panel, and go ahead and start reading.
Sure. Through the combined operation of the 3 statutes in the Commonwealth of Pennsylvania effectively bans 18 to 20-year-olds from carrying firearms outside their homes during a state of emergency. Madison Lara Sophia Knepley and Logan Miller, who were in that age range when they filed this suit, want to carry firearms outside their homes for lawful purposes, including self-defense. They,
Okay.
along with
Basically, what is going on here is that 3 people sued saying, hey, we are over 18, but under 21, we want to carry firearms. Pennsylvania put it like there was an emergency firearms act thing that forbid people from under 21 from carrying firearms. Pennsylvania is a open carry state. So this is not about this is not about like concealed carry. This is open carry. Just wanted to get that right. So I
can you
the discussion.
conceal or open carry if you're less than 21, or it's nothing until you're 21?
Well, you can open carry if you're under 21, but they try to make it so you can't carry.
Okay.
All right, go ahead.
The Second Amendment, controversial in interpretation of late, is simple text. A well-regulated militia being
this is all
law necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Constitution, Second Amendment. In Heller, the Supreme Court held that regardless of militia service, the Second and 14th Amendments guarantee to an individual the right to possess a handgun in his home for self-defense. In that opinion, which addressed a District of Columbia law that banned handguns and required firearms in the home to be rendered and kept inoperable at all times, the court observed that the challenged law would be unconstitutional under any of the standards of scrutiny applied to the enumerated constitutional rights. We and other courts had interpreted that observation as endorsing a means and scrutiny analysis in Second Amendment cases.
But Bruin knocked that down. So here we go.
Then last year, New York State Pistol and Rifle Association Incorporated versus Bruin, the Supreme Court held that the Second Amendment and 14th Amendments protect an individual's right to carry a handgun outside the home. The court rejected means and scrutiny in the Second Amendment context and announced a new two-step analytical approach. The first step, a court determines whether the Second Amendment's plain text covers the individual's conduct, that the textual analysis focuses on the normal and ordinary meaning of the Second Amendment language. Quoting Heller, if the text applies to the conduct at issue, the Constitution presumptively protects that conduct.
Basically, we all know what that says. The second step, the first step is the plain text. The second step is once you say, hey, once the plaintiffs say, hey, you know, it's not covered, and they prove that the Second Amendment doesn't say that they can ban 18 to 20-year-olds from carrying firearms, then it's up to the government to prove that there is a historical analog from the founding era that shows that it is constitutional, which you couldn't do.
Naturally.
Yeah. So we can skip all of this. And now we want to get into the people, because a lot of people, this is where a lot of debate happens here. What are the people?
For sure.
The people during the founding era was anyone 18 and older. That's what the founders considered the people. Basically,
correct.
Right to vote.
Yeah.
You are the people. So let's go from there.
In defense of Pennsylvania statutes, the commissioner first argues that 18 to 20-year-olds are not among the people protected by the Second Amendment, and the appellant's challenge therefore fails the first step of the Bruin test. This is an issue of first impression for us. To succeed on this argument, the commissioner must overcome the strong presumption that the Second Amendment applies to all Americans. In Heller, the Supreme Court reiterated the people refers to a class of persons that are part of the national community or who have otherwise developed sufficient connection with this country to be considered part of the community.
Yeah, basically, this is my thoughts on it. In other parts of the Constitution, if there's an age limit, that they actually state the age limit. Like there's an age limit to
be a congressman, to be a senator, to run for president.
Yeah, but they didn't put an age limit here.
That's a good point. I mean, is there historical, is there documented tradition and historical validity to 18 being the age of when you're? I mean, is that documented anywhere?
There were some militia laws back then that stated that, so they could reference that. Okay. I don't exactly agree with it, but they could always go for that. So that's kind of a harder barrier to overcome than the 18 to 20-year-old. That's why a lot of people don't challenge the under 18.
Yeah.
All right.
So the court also explained that, like other references to the people in the Constitution, the term unambiguously refers to all members of the political community, not an unspecified subset. Accordingly, there is a strong presumption that the Second Amendment right belongs to all Americans. Bruin once again affirmed the broad scope of the Second Amendment, stating that the amendment guaranteed to all Americans the right to bear commonly used arms in public, subject to reasonable, well-defined restrictions. Taking our cue from the Supreme Court, we have construed the term "the people" to cast a wide net. We considered an as-applied challenge to the constitutionality of a federal statute that barred the defendant from purchasing firearms because of a state-level conviction for having made a false statement to obtain food stamps.
Yeah.
We held that the Supreme...
Stop right there. Range versus Attorney General is a very interesting case. There was a guy who committed food stamp fraud like 30 years ago.
Oof.
And so they basically took away his gun rights for life. He is
Wow.
Wow.
and that is probably heading to SCOTUS right after the current case that is challenging it. That's the case that I really wanted SCOTUS to take before the case from down in Texas with the guy that was a dirtbag.
Yes.
That's a criminal. But
We held that the Supreme Court's past references to law-abiding citizens did not mean that a criminal conviction removes an American citizen from the people.
oh, sorry. Let me get back over here. All right, we can skip a bunch
yeah.
of that. All right, go down to the commissioner.
The commissioner endeavors to argue around that conclusion by saying that at the time of the founding, and indeed for most of the nation's history, those who were under the age of 21 were considered infants or minors in the eyes of the law, meaning that they had few independent legal rights. True enough, from before the beginning and through Reconstruction, those under the age of 21 were considered minors. William Blackstone commentaries on the laws of England, so that full age in male or female is 21 years. Who till that time is an infant and so styled in law. Let's see, skipping forward. Persons within the age of 21.
You can step down to notwithstanding legal status.
Notwithstanding legal status of 18 to 21-year-olds, during that period, however, the commissioner's position is untenable for three reasons. First, it supposes the first step of Bruin analysis requires excluding individuals from the people. If they were so excluded at the founding, that argument conflates Bruin two distinct analytical steps. Although the government is tasked with identifying historical analog at the second step of Bruin's analysis, we were not limited to looking through the same retrospective lens at the first step. If at step one, we were rigidly limited by the 18th century conceptual boundaries, the people would consist of white landed men that obviously not the state of law. Noting that the Second Amendment's reference to arms does not apply only to those arms that existed in the 18th century. Observing founding era gun restrictions based on race and religion, such as those Loyalists, Native Americans, Quakers, Catholics, and Blacks, would now be unconstitutional under the First and 14th Amendments. Second, it does not follow that just because individuals under the age of 21 lacked certain legal rights at the foundings, they were ex ante excluded from the scope of the people, as then Judge Barrett explained. Neither felons nor the mentally ill are categorically excluded from the national community.
That was that was Amy Coney Barrett before she became a Supreme Court justice.
Gotcha.
Wow. Oh, Barrett. Okay. But that does not mean that the government cannot prevent them from possessing guns. Instead, it means that the question is whether the government has the power to disable the exercise of a right that they otherwise possess.
Heyo.
Third, consistency has claim on us. It is undisputed that 18 to 20-year-olds are among the people for other constitutional rights, such as the right to vote, freedom of speech, peaceable assembly, government petitions, and the right to right against unreasonable government searches and seizures. As we recently observed in Range, there is no reason to adopt an inconsistent reading of the people. Indeed, wholesale exclusion of 18 to 20-year-olds from the scope of the Second Amendment would impermissibly render the constitutional right to bear arms in public for self-defense a second-class right, subject to an entirely different body of rules other than the Bill of Rights guarantees. Wow.
Yeah.
We therefore hold that 18 to 20-year-olds.
That was a quote. That was a quote in a quote. It was quoted from Bruin, but that was quoting from McDonald.
Mm-hmm. We therefore hold that 18 to 20-year-olds are like other subsets of the American public, presumptively among the people to whom the Second Amendment rights are extended.
If
Oh yeah.
case
Let's see.
if case was on appeal,
If case was on appeal and Bonta was vacated and remanded to the district court for consideration in light of Bruin, the analysis are nevertheless instructive. In Hirschfeld, the Fourth Circuit, after reviewing the use of the people in the rights enumerated in the First and Fourth Amendments, expressed its view that it had to conclude that 18 to 20-year-olds have no Second Amendment rights, where almost every other constitutional right affords them that protection. In a variant on familiar canon of construction, the Fourth Circuit also explained that when the drafters of the Constitution and its amendments wanted to set an age restriction, they did so explicitly.
basically what I was talking about, what we talked about.
Yeah.
The Ninth Circuit, Bonta reached the same conclusion about age limits but on a different basis. It determined that the Second Amendment protects the right of the people to keep and bear arms, refers to the militia, yet young adults were part. There is any argument made that the Commonwealth can restrict the rights of 18 to 20-year-olds with respect to firearms. Bruin teaches us that the commissioner must make that argument by showing that such restrictions are part of the nation's historical tradition of gun regulations. Boom.
Damn.
So basically, they're saying, so you failed the first part. Now let's go to the second part.
The commissioner does not seek to shoulder that burden, but before considering whether he has succeeded in his task, he must establish.
It says does seek, not does not seek. Sorry.
Oh, sorry. Yep. Thank you.
Yep.
Task. We must establish which period the Second Amendment's ratification in 1791 on the 14th Amendment ratification in 1868 is the proper historical reference point for evaluating the contours of the Second Amendment as incorporated against the Commonwealth. The appellants direct us to 1791, but the commissioner insists that 1868 is the correct temporal reference point. Bruin declined to resolve this time frame question because in that case, the public understanding of the Second Amendment right at issue was the same in 1791 and 1868 for all relevant purposes.
We are situated.
I don't know where we are now.
We are situated differently.
Oh, we are situated differently because the Commonwealth has not pointed to an 18th century regulation barring 18 to 20-year-olds from carrying firearms. He says that there are dozens of 19th century laws restricting 18 to 20-year-olds' ability to purchase, possess, and carry firearms. A premise we begin with that the individual rights enumerated in the Bill of Rights and made applicable against the states through the 14th Amendment have the same scope as against the federal government. And there's
all that. That's just voting. So let's get down here.
In those cases, the court interpreted the bounds of the Sixth, Fourth, and First Amendments, respectively, according to their public meaning at founding. In Crawford, which considered the scope of confrontation clause of the court, observed that the right to confront one's accusers is a concept that dates back to Roman times, but the emphasis in the opinion was on the English common law because it was the founding generation's immediate source of the concept.
Basically, just going over the founding era, explaining what the founding era is and stuff like that.
Mm-hmm.
While the Supreme Court has not held that all constitutional rights that have been made applicable to the states must be construed according to the public meaning in 1791, the commissioner has not articulated a theory for defining some rights according to the public meaning in 1791 and others according to the public meeting in 1868. Moreover, Bruin has already instructed that historical evidence from 1791 is relevant to the understanding of the scope of the Second Amendment as incorporated against the states in Bruin. Accordingly, to maintain consistency in the interpretation of the constitutional provisions, we hold that the Second Amendment should be understood according to its public meaning in 1791.
Basically, what they're saying is that, hey, because what Pennsylvania tried to argue is that the founding era was 1868, which was the ratification date of the 14th Amendment, and like I've always said, the reason why they do that is because during the Reconstruction period after the Civil War, there's a bunch of new gun laws because they were a bunch of Jim Crow racist laws to
Yeah.
prevent black
Mhm.
people from getting guns. Hey, Dark, you want to take over?
Sure. Yeah. Let me
Richard,
pull it
you're
up.
breaking up a little bit. So
Here, sorry, I gotta pull it up. Give me one sec. Okay. More to the point.
now,
Is that where we're starting?
let's go down for some reason.
Okay, hang on. Now the whole thing is
Give me 1 second here.
okay. I'm back now.
All right, the commissioner.
Okay, the commissioner contests the relevancy of the second Militia Act on three grounds. First, he notes that to the extent 1791 militia laws have any relevance, the UFA contains an exception for members of the military and National Guard, and is thus entirely consistent with them. Second, he objects that when the Second Amendment was ratified, 9 states set the threshold for militia service at 16, and 7 states set the maximum age at 50. Excuse me. According to the commissioner, the logical extension of appellant's argument that militia laws in 1791 determine the scope of the Second Amendment would also require the invalidation of any contemporary law restricting 16-year-olds from purchasing, possessing, and carrying firearms, but would allow laws stripping 51-year-olds of the right to keep and bear arms. And third, he asserts that the Second Militia Act of 1792 shall be invaded. Hold on, where we go? Shall be invaded or be in imminent danger of invasion from any foreign nation or Indian tribe. First Militia Act of 1792, as well as similar state statutes that require 18 to 20-year-olds to participate in the militia, often assumed that militiamen younger than 21 did not have the independent ability to acquire firearms and therefore required their parents to provide them with arms. No doubt the commissioner is correct that a duty to possess guns in a militia or National Guard setting is distinguishable from a right to bear arms unconnected to such service. Good point. Let me see
That's
here.
Bondi goes still.
Still, the Second Militia Act is good circumstantial evidence of the public understanding at the Second Amendment's ratification as to whether 18 to 20-year-olds could be armed, especially considering that the commissioner cannot point us to a single founding era statute imposing restrictions on the freedom of 18 to 20-year-olds to carry guns. The commissioner's contention that any relevance on where's it pick up? 1789 militia laws would force us to invalidate laws prohibiting 16 to 17-year-olds from possessing firearms is simply not persuasive. Although the age of militia service dipped to 16 in some states during the colonial and revolutionary periods, a development that likely can be attributed to necessities created by ongoing armed conflicts. The appellants rightly observe that at the time of the Second Amendment's passage or shortly thereafter, the minimum age for militia service in in every state became 18. Finally, e- finally, right?
Yeah.
Even though there were founding era militia laws that required parents or guardians to supply arms to their minor sons, beautiful. Nothing in those statutes say that 18 to 20-year-olds could not purchase or otherwise acquire their own guns. We understand that a reasonable debate can be had over allowing young adults to be armed, but the issue before us is a narrow one. One question is whether the commissioner has borne his burden of proving that evidence of founding era regulations supports Pennsylvania's restriction on 18 to 20-year-olds' Second Amendment rights, and the answer to that is no.
Yeah, then they try to moot the case. Being a moot the case is a legal tactic where they just change the law, whatever, just to get rid of the case. So the government tried to argue that the case was moot. So go ahead, take it from here, Dark.
Mm. The commissioner next argues that none of the foregoing matters because the appellants no longer face any restrictions on their ability to carry publicly, which eliminates any injury for which they could obtain relief. In other words, he says the case is moot. He points to the amendment to Pennsylvania's Constitution that now limits the governor's authority to issue an emergency declaration to 21 days, unless the General Assembly votes to extend it. And
Basically, the governor can only do 21 days. This is an emergency thing. They're saying that 21 days is over. So therefore, there's no more lawsuit because it's over.
beautiful.
But,
Says, and
but they rejected it.
yeah,
All right. Go from and.
and he notes.
Yeah.
And he notes that emergency proclamations in place when this suit began have all lapsed. Accordingly, the commissioner says there is no longer any restriction on the appellant's ability to openly carry firearms. He also argues that the claims of the individual appellants are moot because they have reached the age of 21 and are now eligible to apply for concealed carry license. Generally, a case is moot when the issues presented are no longer live or the parties lack a legally cognizable interest in the outcome. That's right, cognizable, right?
Yeah. Let's go.
Close enough.
Yeah. Yeah. Good
Uh, is here the appellants invoke the capable of repetition yet evading review exception to the mootness rule, which applies only in exceptional circumstances when one, the challenged action is in its duration too short to be fully litigated prior to cessation or expiration, and two, there is a reasonable expectation that the same complaining party will be subject to the same action again.
Okay. Basically, they're saying that the case isn't moot. So, yeah. All right. Let's go down to the appellant's claim is not barred by the 11th Amendment or Article 3 standing.
The commissioner's next salvo is, in essence, they've got the wrong man. He says that the target of the appellant's constitutional challenge is Pennsylvania's licensing scheme, not him, and that suing him is improper because he is powerless to issue licenses. More specifically, he says that the ex parte Young exception to the 11th Amendment, the exception that allows suits against an official who is, quote, representative of the state, is properly invoked only if the named defendant has a sufficient connection to the enforcement of the challenged law, as distinct from a generalized duty to enforce, and if there is a real potential that the official will in fact enforce the law.
Okay, basically he's saying, hey, you might be right, but you're suing the wrong person.
You got the wrong guy.
Yeah, basically.
The appellants have a ready and effective response. They say they are agnostic as to whether they get licenses to carry concealed weapons under blah 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 blah. Oh, just yeah.
Yeah.
Or whether despite 6107, they can carry openly without a license during an emergency. In other words, the existence of a license is not what they are fighting about. It is the right to openly carry a gun regardless of a state of emergency. and they contend that enjoining the commissioner from arresting 18 to 20-year-olds who openly carry firearms would in fact redress their constitutional injuries.
Yeah,
When you
what they were trying to do is say, hey, we're not responsible for concealed weapons permits, but the issue is they weren't ever challenging the concealed weapons permit.
Yeah.
Now go to F.
The appellants have not waived their request for injunctive relief, and their request is sufficiently specific. Finally, the commissioner asserts that the appellants forfeited their request for injunctive relief and failed to adequately describe the relief as required under Federal Rule of Civil Procedure. That argument fails too. The appellants repeatedly referenced their request for injunctive relief throughout their opening brief, and they discussed each of the elements of the preliminary injunction test, citing case law in support. The issue of injunctive relief, therefore, should not be a surprise to anyone in this case. The commissioner had a full opportunity to develop a response in his answering brief. That's all.
But they didn't do it. All right, go ahead.
For the foregoing reasons, we will reverse the decision of the district court and remand with instructions to enter an injunction forbidding the commissioner from arresting law abiding 18 to 20-year-olds who openly carry firearms during a state of emergency declared by the Commonwealth.
Basically, what they're doing is they're going to send the case down to the district court and tell the district court to enter in an injunction forbidding. So they're not going to issue the injunction. A judge who originally ruled for Pennsylvania is going to have to enter a injunction against Pennsylvania.
Wow.
There was one dissent who is an Obama appointee, of course. And she tried to argue that the people is 21. Under
Good
21
for
is
you.
not part of the people. That was her whole entire argument. So it's a trash argument, and it's just a way of being trash.
Yeah.
So that is in the description, and now we can go to the second case here, which is a GOA case. So that was an FPC case, and now the next victory here, which is freaking fantastic, is a GOA case. So I'm going to bring this up here. I'm going to blow this up a little bit.
And while you pull that up, the Sentinel says this argument has little to zero merit. Pennsylvania Constitution describes the quote duty Pennsylvanians have. Yeah, and the funny thing is, I believe that they know that you know what I mean. I believe they know that their argument has zero merit.
Yeah, so the question is always, are they just stupid or are they devious? And sometimes it could be a little of both.
Yeah.
But
yeah, it could be. Now, this one deals with Philadelphia and carrying guns in public parks and stuff like that.
Okay. You want me to jump in?
Go ahead.
Gun Owners of America, Inc., Gun Owners Foundation, Terrence Ledwell, Laura Leonard McBride, Edward McBride, and James Sandifer, collectively gun owners, sought an injunction to prevent enforcement of an executive order of the mayor of the city of Philadelphia prohibiting guns in city-owned recreational areas.
Let me just show you one thing. This is a state level court.
Okay.
I just wanted to point that out. The other one was federal. This is state level.
The Court of Common Pleas of Philadelphia County granted the injunction, holding that the Pennsylvania Uniform Firearms Act of 1995 preempted the executive order. The trial court denied the city's post-trial motion. The city appeals. We vacate and remand to the trial court for further proceedings.
All right. So here you go. Basically, the executive order violated preemption in Pennsylvania, which means that no law can be more restrictive than the state law. So,
in September of 2022, the mayor issued the executive order, which provided in pertinent part 1. Weapons prohibited. No one carrying firearms or other deadly weapons is permitted to enter or remain in or on any indoor or outdoor recreation premises operated by the Department of Parks and Recreation. Um, the department, including any recreation center, ball field, court, playground, pool, tot lot, or similar facility, but excluding park trails and passive park space. This management and operational policy prohibiting firearms and other deadly weapons at city recreation facilities shall apply exclusively to the list of city-owned premises attached hereto as Exhibit A. The commissioner of the department may designate additional city recreation facilities, of course, subject to this policy, provided that an up to date list of all premises covered by this policy shall be posted on the department's publicly accessible website.
Yeah, that's because everyone goes and checks the websites of the government before we go carry guns.
Of course. Yeah, absolutely. I know I do all the time.
All right, go ahead.
JK. Gun owners commenced this action in the trial court seeking a declaratory and injunctive relief to prevent enforcement of the executive order. They asserted that the executive order violates the UFA's preemption of local firearms regulations and the Pennsylvania Constitution. Facts. Gun owners sought a preliminary injunction to forestall enforcement of the executive order during the pendency of their complaint in the trial court. The trial court accordingly scheduled an emergency hearing just 3 days after gun owners filed their complaint. At the hearing, the trial court stated that it would consider gun owners' motion as for preliminary relief. Reproduced record, blah, blah, blah. However, the trial court then decided to convert the hearing to one regarding permanent injunctive relief on the basis that the case hinged purely on legal questions. The city objected, but the trial court nonetheless proceeded with a final injunction hearing. On October 3rd, 2022, the trial court entered an order granting permanent injunctive relief. This appeal by the city followed. Apparently, DLD After Dark will have Babyface P on to discuss his new SOT at 10 p.m. Eastern tonight. Oh, whoops. I'm sorry. I thought I was reading this court document. In its only argument relevant to our disposition of this appeal, the city posits that the trial court shall not have granted a permanent injunction after an emergency hearing held just days after gun owners filed their complaint. We agree. The city alleges that the trial court erred in conducting a final injunction hearing and granting permanent injunctive relief without allowing discovery and only days after gun owners filed their complaint, the city asserts.
The city asserts that
That
the court may not convert a motion for a preliminary injunction into one seeking a permanent injunction unless all of the parties consent. Here, it is undisputed that the city expressly objected to converting the preliminary injunction hearing into a final injunction proceeding at such an early stage. We agree with the city that the trial court erred by converting the preliminary injunction hearing to a final hearing on the merits of the permanent injunction in the face of the city's objection. This court has held that a court generally may not change the nature of a preliminary injunction hearing by converting it to a permanent injunction proceeding unless all of the parties have agreed to the change.
All right. So basically, they're saying that go down to notably.
Notably, the trial court's belief that gun owners' complaint raised pure legal questions did not allow the trial court to convert a preliminary injunction proceeding into a final injunction hearing over gun owners' objection. This court recently vacated a similarly premature disposition of an injunction request that turned on a legal issue. In Prestige Design, the plaintiff filed a civil complaint seeking permanent injunctive relief and also filed a motion for a preliminary injunction. However, 2 days after the city responded to the plaintiff's preliminary injunction motion, And without any evidentiary hearing, the trial court dismissed the action on the basis that, quote, the entirety of the relief sought in the complaint was identical to the relief sought in the motion for a preliminary injunction. On appeal, we vacated the dismissal, explaining that.
Hold on, sorry about that.
You're good.
Okay, just go to here.
Here, the city points out that it had only 29 hours to file a brief in response to what the trial court later deemed a case dispositive motion by gun owners. The city posts that it did not have a fair opportunity to develop its legal arguments fully. In addition, with only 3 days to prepare for the hearing, the city insists that it was unable to present its full case, which it asserts would have underscored the executive order's significance as both proprietary function and a purely what? Proprietary
Local
function
matter.
and a purely local. Okay, got it. And purely local matter, as it is tied to issues of employee safety and property management. It was also key to making a record on the balancing of equities for injunctive relief. Specifically, with respect to balancing the equities, a permanent injunction order requires the moving party below to establish that 1, the right to relief is clear, 2, the relief is necessary to prevent an injury which cannot be compensated by damages, and 3, greater injury will occur from refusing the injunction than from granting it. The city maintains that.
Or that just go
Mayor's briefing would not. Okay, yeah, we'll just go
let's
down.
go down to the conclusion.
Okay. Based on the foregoing discussion, the trial court's order is vacated, and this matter is remanded to the trial court for further proceedings consistent with this opinion.
Okay, so basically what is going on here is that they say that it should only been a temporary injunction and not a permanent injunction, but they did a permanent injunction, so they're going to remand it back down where it will become a temporary injunction, and then they're going to have to do a trial for a permanent injunction.
So they could skip the trial. They could just say, okay, permanent injunction now.
No,
Or they would say,
no, they have to have oral arguments and
okay.
everything, briefings, stuff like that.
And did I read that correctly that all parties would have to agree?
Only if they went to convert a temporary injunction to a permanent injunction.
Gotcha.
So that's basically saying, okay, well, this is going to be a permanent injunction. Basically, they'll never agree to that. They're going to want to argue in court.
Mhm.
Roger that.
So, yeah. So that is what is going on here. So those are the two rulings. I'm going to get back to the first ruling, the federal court with the 18 to 20-year-old ruling first. I think that this is, where did Rich go? Okay, he keeps on removing himself, but that's fine.
Yeah, I think he may have a reason. Oh no, he doesn't.
Okay, so this was the last one was on the state court, the Court of Common Pleas, and the first one was the Fourth Circuit. With the first one, it was remanded back down. But I think what's going to happen is that the state is going to ask for an en banc, meaning the full bench will hear the case because the fourth is really anti-gun, whatever. And then what they're going to do is they're going to try to get it stayed until they hear it.
Now, what kind of impact do you see this having potentially on nationwide 18 to pre 21-year-old, right? 18 to 20 year and 11.9-month-old adults. Do you think gun
Or this
shops?
is Third Circuit Court of Appeals, not Fourth Circuit. Sorry. What I think it's going to be referenced in other cases, like range was referenced in this case. So I believe that they're going to reference it. I mean, it's not binding to any other court,
Hmm.
circuit courts, so it's not binding to the fourth, fifth, sixth, or whatever. But what I think will happen though is that I think that other courts will look at this and say, hey, we're going to rely on this decision, because that happens a lot where one circuit makes
Well,
a decision and the other one uses that. And I'm sure other cases that are challenging challenging carrying of a firearm between someone 18 to 20, I'm sure other cases are going to file what's called a motion of supplemental authority, with
Hmm.
saying, hey, look, this other circuit court, which is your peers, ruled this way.
Yeah. Yeah, we've seen that in some other cases in the past.
But do I think it's gonna have like it's not like a nationwide injunction against it. It's not like for example, pistol braces, right? The
Hmm.
Fifth Circuit issued a nationwide injunction against ATF enforcing uh, the pistol brace ban. I don't think that's gonna happen here.
Okay, so this won't be like a nationwide door opening for.
No, because the circuit court didn't even issue any relief. What they did is instruct the district court to issue the proper relief.
Okay, okay,
They're saying, hey, district court, you messed up. You should have issued a preliminary injunction against this. You did not issue an injunction. Go back and issue the proper relief.
gotcha.
So their hands are tied. Now they have to issue that relief. They
Yeah,
might not agree with it, but they have to issue that relief because the circuit court told them that they screwed up.
interesting.
so
Yeah.
wasn't there another 18 to 20-year-old case that I thought was like a federal district level?
There is one down in Texas, but that's for buying a gun.
Oh, purchase. Okay, so it wasn't keep and bear.
And there is one in the 11th Circuit that didn't end up. That was challenging a Florida law, and that basically was where the whole 14th Amendment thing came out of.
So that's
But
what
Mhm.
I was wondering, like
that was
Rich was
vacated
asking.
because that's been granted en banc by the 11th. So that was vacated. So that's like the three-judge panel decision never happened. When a case gets granted en banc, the three-judge panel decision is vacated. So it's like a do-over. It's like it's never happened.
Mhm.
It's no longer an authority. In fact, if you look at the Maryland shall issue versus Maryland case, dealing with the firearms, the purchase permit, they tried to reference the three-judge panel in the 11th Circuit. They filed a motion of supplemental authority, and after it was granted en banc and that case was vacated, they never withdrew it. So the court said, "Hey, your supplemental authority is BS because it was vacated, so it's like it never happened."
Mhm.
Hmm. Yeah, I guess my thought was that with all of these cases happening, specifically around 18 to 20-year-olds purchasing firearms, carrying firearms, bearing firearms, or arms rather. It's just kind of making me think like, okay, so then when potentially could we see, FFLs opening up their doors to 18 to 20-year-olds to purchase handguns? That's kind of and I'm not asking
There,
you that. I'm just kind of saying that was my thought process on it.
there is a case challenging the ban on 18 to 20-year-olds from buying handguns from FFLs. That there is a positive ruling in that, but it has been stayed until the Supreme Court decides to take it or not.
Mm. Gotcha.
So we'll have to see.
Dope. We'll see what happens. Yeah, Farmer James, you're correct. It's same way in Virginia. Aside from places that
What
have
what
constitute.
what this isn't challenging concealed carry permits. This is
Yeah,
challenging open carry. In Virginia, you can open carry at 18.
yeah. An 18-year-old could open carry a handgun at 18.
18 and an 18-year-old can also buy a handgun in Virginia. That's why right now in the
Yeah.
Lynchburg case, they made an exception. The state has an exception. So if you are under 21, you can buy a handgun from a private seller
Mhm.
without going through a NICS check.
Yeah.
But all other humans can't peer to peer transact.
Yes, correct, which is
Wow.
absolutely ridiculous.
What if I just identify as 18?
There's a movement. I mean, there is movement in the case that's challenging universal background checks in Virginia and down in Lynchburg.
There's some other things happening in Virginia right now
The
as
Roanoke,
well. Well, no, I just mean
Worth County
the
Roanoke. Oh,
potential the bills. Yeah,
yeah. Hopefully, Youngkin will veto them when they get to the desk, if they get to the desk.
yeah.
I don't think all of them will get to his desk. Probably a couple, but
Yeah.
I don't think they will all get to the desk because our Democrats are a little bit better than Florida's Republicans.
Mm,
Because yesterday, Florida Republicans killed open carry.
dang.
What?
Oh, you didn't hear that?
I didn't
No.
hear that either.
Yeah, the Republicans killed the open carry bill.
But they've always done that. So we have permitless concealed carry in Florida, but no open carry. We're one of 4 states in Florida that do not permit open carry.
It's insane. I don't understand it.
They claim it's about tourism.
Yeah.
Hello, fellow teenagers.
Oh, that's great.
But his hair identifies as trans.
Yeah, right. Rich
Oh, yeah.
shows up.
I'll get the cap with dreads hanging out.
Yeah. Is there any questions before we get out of here? I was going to do a live because I just didn't feel like shooting a video about all this. So,
You know, while we wait for people in chat to respond with any potential questions, I think that it may be a good idea for us to pull the bills and pull them up and do a stream, just having a conversation about them in Virginia because,
yeah, we can do that. I did a video going over all of them,
yeah,
but we can do do a like Virginia special, whatever.
man, Virginia is such an important state, man, and it's great to see people from all over the country come to Virginia and show up on Lobby Day, and which I actually didn't go this year, but to see that it's inspiring.
Yeah, I'm
It's a
going to.
battleground state.
I'm going to try to get. Well, I'm not going to try. I will. I'll get Philip Van Cleve on the show on John Crump Live to discuss the bills.
Yeah, I actually sent them a super chat saying, "Hey, would you go on John Crump Live?"
Yeah, they've been on the show before. I can get them on. I'm going to get Nick Freitas on the show as well.
Yeah,
Oh, cool.
I didn't know that you guys had him on before.
Yeah.
Yeah.
Phil's a cool guy. Phil and I, we talk every once in a while.
I met him back in the day when I was a kid. I had barely any idea what VCDL was, and he was out there personally at a gun show for trying to get memberships. And fast forward to where we are now, and you usually don't see Philip out there hustling for memberships. But
Show us some nipple crump. No.
don't be such a tease. Oh, that's great. But
All
yeah,
right.
go ahead.
So let's go ahead and wrap it up. Thank you for watching, guys. Follow DLD After Dark at DLD After Dark and DLD TV.
Oh, that's right.
Now,
I do have my new channel now.
New channel. You having Babyface P on his show tonight at 10 p.m. ish.
Yeah, and for people here that if you're watching this on John Crump News and you don't go to John Crump Live Monday through Thursday at 5 p.m.
We're
Eastern,
not doing it today though.
yeah, I think you guys are. Okay, no problem. But for the most part, in most cases, Monday through Thursday, 5 p.m. Eastern, you guys are missing a huge opportunity to come in and, interact with people within the gun community, the gun world. But also, it's a great show with great guests, and it's funny you go live on here, and you got 140 people in here. So I think those people would love the show. And yeah, follow me on YouTube, DLD After Dark, and I'm DLD After Dark on everything. And find gun building stuff at DLD Hardware. And Rich, you can go ahead.
Well, everything is reachable at flyingrich.com. Most prolific on Flying Rich Firearms on YouTube, Flying Rich on YouTube, and Flying Rich _official on the grams.
All right, and with that, I guess we're done here. So we'll get out of here, and I'll see you guys later. And remember, next week's going to be a light week because we'll be out at SHOT. But on Wednesday on Junk Crump Live, we will be broadcasting from the Otis booth with Stephen Williford, someone from Otis, Walter Keller, and Jordan Vinro.
And are you gonna have time for Clinton from Classic Firearms to pop in there too?
If he wants.
Okay, yeah, I'll connect you guys.
I don't need you to connect me to Clint.
Oh, okay.
He plays Call of Duty, by the way.
Gotcha.
So that's why you should play Call of Duty.
Yeah.
I played Call of Duty with some rapper the other day.
Yeah.
Yeah. He actually was in Zombies, and there's actually a skin that the Call of Duty did for him, and it was like he was playing in his own skin.
Crump, can you read this for me?
We Americans must learn to trust those bureaucrats that run our government departments and agencies. No.
Is this so? I'm wondering, like this has got to be him being facetious. Right?
He's being facetious.
Okay. All right. Yeah, I sensed sarcasm in, but I was like, hold on, are we serious here? Or? Don't worry, Wolfman. Crump is too.
Yeah, and I'm not playing. I'm about to.
I'm just playing.
All right, guys. I'll see you guys later.